Welcome, everybody. Good evening. My name is Lydia Nussbaum, and I'm the director of our Saltman Center for Conflict Resolution. I'm also the Associate Dean for Experiential Legal Ed and director of the clinics here at the William S. Boyd School of Law at UNLV. So I'm going to start our program tonight with reading our university's land acknowledgement. The University of Nevada, Las Vegas wishes to acknowledge and honor the indigenous communities of this region and recognize that the university is situated on the traditional homelands of the Nuwu Southern Paiute people. We offer gratitude for the land itself, for those who have stewarded it for generations, and for the opportunity to study, learn, work, and be in community with this land. We encourage everyone in this space to engage in continued learning about the indigenous peoples who work and live on this land since time immemorial, including the Las Vegas Paiute tribe and the Moapa Band of Paiutes. So as one of the most diverse universities for undergraduate students in the United States, UNLV believes it's important to recognize and appreciate the use of Southern Paiute lands as part of its mission to be a welcoming and inclusive place for working and for learning. So thank you again for being here tonight for this fabulous Beecroft lecture that we're about to have in a few moments. But to start us off with a welcome, I'd like to introduce Dean Leah Chan Greenwald, the Dean of our Boyd School of Law and the Richard J. Morgan Professor of Law.
Thanks so much, Lydia. Welcome to everyone to the Boyd School of Law at UNLV and to the Saltman Center for Conflict Resolution for tonight's Memorial Beecroft Lecture on Conflict Resolution. We are truly honored to have with us here tonight members of the Beecroft family, Christine and her son Jonathan, as well as so many members of the Boyd community, both friends and alumni. Thank you really all so much for making the trek out here, and we really appreciate having you. The Saltman Center for Conflict Resolution was founded here at Boyd Law 20 years ago. The Saltman Center's founders, Michael and Sonia Saltman, had the creative vision, together with the founding dean, Richard Morgan, to build a center at the law school that would be a forum for advanced study of conflict. What drives conflict and how can we resolve it? Under founding director Gene Sternlight and our current director, Lydia Nussbaum, the Saltman Center has supported scholarly research and developed a dynamic dispute resolution curriculum for our current law students, along with education to the wider community through its lectures, conferences, and workshops. Through its programming, the Saltman Center explores a wide array of disputes, public, private, local, regional, national, and international, with the aim of improving our understanding of what drives conflict and how we can be better equipped to address it. We are profoundly grateful to Michael and Sonia Saltman for their boundless energy, their inspiration, and of course, their generous support. They are sorry that they cannot be here with us tonight, but they send their well wishes to all of you. We are also grateful to the Alternative Dispute Resolution section of the State Bar of Nevada, which continues to sustain the Beecroft Memorial Lecture in memory of ADR Commissioner Chris Beecroft Jr. Here to say a few words is Shirley Blazich, chair of the ADR section. Shirley?
Hi, good evening, everybody. I'm Shirley Blazich, chair of the ADR section. Just to say a couple of words, I just want to say thank you to everybody for being here today. Obviously, this is an important lecture series, and it's something that we're very proud of. We are happy as the ADR section to be able to support this event, and we just want to say thank you to the Boyd School of Law and the Saltman Center for encouraging this event and for giving it a home in this beautiful university campus every year. Of course, as the chair, I have to plug the section just for a couple of minutes. There's a lot of familiar faces here. I know there's a lot of people who are already members. For those of you who are not members, I would very much encourage you to join. You can find information on the State Bar's on the State Bar's website, and you can certainly come talk to me afterwards, and I'll help you with some additional information. For those of you who are law students, you can join for free. And for those of you that are practitioners, it's only $25 to join. The ADR section is really passionate and committed when it comes to providing continuing education to the legal community and to really promoting awareness about alternatives to litigation within the larger Nevada community. So we've got a lot of exciting events that are happening right now and coming up. And in the future, our next meeting, just so it's on everybody's radar, is on March 21st. And we will be having retired Judge David Jones providing us with a 30-minute CLE presentation during our meeting. So a lot of fun events happening like that. And anyone is welcome to join and be part of this great ADR community that we have in our state. So with that, thank you very much, and I will turn it back over to Lydia.
Thank you, Ms. Blazich, and thank you, Dean Greenwald. So now I get to have the distinct pleasure of introducing tonight's speaker, Professor Maureen Ariano Weston, who's a professor of law at Pepperdine University Caruso School of Law, where she also serves as the director of the Entertainment, Media, and Sports Dispute Resolution Project. So Professor Weston is a true child of the Rockies. She, in fact, told us that she had to come to Las Vegas and leave behind 5 inches of fresh powder that had just landed in the Colorado Rockies. So we're so grateful to you for being here tonight. So Professor Weston received her JD from the University of Colorado and her BA in economics and political science at the University of Denver. And before becoming a law professor, she practiced law for a number of years at Holm, Roberts & Owen and Fager and Benson, both firms in Colorado. And Professor Weston teaches courses in arbitration, mediation, negotiation, international dispute resolution, legal ethics, and American and international sports law. She's the co-author of 3 major case books on sports law and arbitration, including Sports Law, Cases and Materials, which is in its 9th edition. And she has written dozens of articles in the area of Olympic and international sports arbitration, disability law, sports law, intellectual property as they relate to student-athletes' likeness, and, of course, dispute resolution. And you can read more about her wide-ranging and really creative scholarly work on her faculty bio page on the Pepperdine website. So Professor Weston doesn't just talk the talk, she walks the walk. She is an arbitrator. She is a member of the American Arbitration Association. She's an arbitrator with the AAA as well as with FINRA. She's highly involved in service and in developing programs for students to gain experience in negotiation, mediation, and arbitration. She advises the Sports Law and Entertainment Dispute Resolution Journal. She's a coach for the ICC Mediation Advocacy and Sports Entertainment Law Negotiation Competitions, and she's held important leadership positions in the American Association of Law Schools, AALS, Sports Law Section. She's a member of the Sports Lawyers Association, Colorado Law Alumni Board, the National Sports Law Institute, and serves on the editorial board of Law in Sports. She's an incredibly busy, creative, and active person, and we are just so thrilled to have her with us here tonight. So come on up, Professor Weston, and please join me in welcoming her.
Thank you.
Our plan for tonight is for Professor Weston to talk for
Just give me the hook.
A while.
But 30 minutes-ish, but
Yes.
I look forward to questions
and then,
as
yes,
well.
we'll have robust time for Q&A at the end, and then we'll, of course, conclude, and
All
hopefully
right.
you'll all join us for reception.
First, I need to give you a hug. Thank you so much. Oh,
to
thank
hear.
you. All right, thank you. And I think it's now time for the reception after that introduction. I forgot that I did that. Okay. Welcome. Thank you for being here, and it's truly an honor to be here at the Beecroft Lecture Series, and I read about your father, your husband, and the contributions that Chris made and continues to make to the Las Vegas community, dispute resolution, and so it's just really an honor to be here and to meet you both. Dean Greenwald, so nice talking with you today, and just thank you for having me. UNLV has 2 powerhouses in dispute resolution in the academic field, and so, with Lydia and Jean, putting UNLV law and the Saltman Center on the map. So I've been here for conferences, and years ago I taught in a sports dispute resolution class, and so I'm quite devoted to the program here and to the people you have. Thank you all for being here. Woohoo, Las Vegas. Let's talk about sports. Las Vegas was non grata for the longest time. And before they were for gambling on sports, they were against it, so the professional leagues, but I just had to, so many eyeballs were on Las Vegas with the Super Bowl and Taylor and Travis, not to mention, that didn't hurt, the NFL loved it. And so Las Vegas is really becoming the epicenter, even though sports gambling is becoming legal at the state level after the Murphy decision. There's nothing like Las Vegas and walking over to Allegiant Stadium. And so I just in the sports world, that we just hear so much about they want to hold all the events in Vegas. So the opportunities for your students and for each other in this space is pretty extraordinary and exciting. So the significance of sports law, people care about sports passionately, as you saw. And why is that? So people wear the jerseys, we identify with our team, and sports really is the last shared experience that we have. It's the last live event that we watch rather than binge watching something on Netflix. So a lot of that we're not tuning into Seinfeld at the same time like we used to. So that makes it draws advertisers, but it provides that community experience for us. And I really love that unifying aspect of us all watching up to the bitter end, and then there's the overtime, and there's even more. So Nelson Mandela has said that sport has the power to change the world. It has the power to inspire, to unite people in a way little else does. And it's more powerful than governments in breaking down barriers, right? So sport is meaningful on an individual level, on a community level, national, international, and I'll be talking about the Olympics and how politics ties into sports as well, because we want our teams to win. We want medals at whatever price it may take. But the global market for sports, right, is extraordinary. 600, all over the place, but globally, a $620 billion market, and it's just going to go. And then with gambling, sports gambling as well, it just continues. The market for this really is insatiable. So it does have impacts on individual and national and global levels with so many aspects. So I talked to my students who are interested in sports, and I said, it's not just being an agent. There are so many pieces in this industry that you can get involved in, starting at the collegiate, youth sports, collegiate, and on the way up. They can't all start being the general manager of the Raiders as much as they want to. So sport, because it is such a vast industry, there's not a specific necessarily sports law, but it's every body of law as it touches the sport industry, as it touches players, employment, contract, IP. I hear we have the big trademark conference going down tonight. Antitrust is big, the labor rights, regulation, and also seemingly rights of non-discrimination, human rights. But sport is also developing its own body of law. They call it lex sportiva, basically the case law that develops through the arbitration decisions. But what law applies in the international context, and where do we go for that, when? In the US, and in all of sport, it's law of private association, it's contract. We decide to create our own pickleball league, or Christine, you and I are gonna set up our own anti-pickleball league, right? Because we're tennis players. But you just decide, each one of us owns a team, what are the rules, this is how we're gonna go. So, and the courts defer to private associations. So as long as the NFL, as long as the NCAA, well, that's another story. But as long as they're following their own rules, then we're gonna leave them alone, but they are, in the US, the sport bodies are subject to US laws, antitrust law, labor law. There still have to be compliance with those laws. I have an asterisk on this because what about international law? And in most of these cases, at least at the professional level, they choose through collective bargaining to resolve their disputes through arbitration. And in the NCAA context, there's a lot going on there. In terms of the NCAA institutional members, there's the infractions process, which is essentially arbitration. Now, the student athletes are not subject to any type of contract with the NCAA, which means, have you seen about all of the lawsuits going on, changing college sports in terms of player rights, rights to publicity, NIL, rights to be employees? So there's a lot going on at that level, but the student athletes are not a party to a contract where they have to go through private dispute resolution. So we're seeing a lot of cases in the courts from that aspect. I'm going to focus on Olympic and international sports. And the regulatory bodies, it's different because you have different regulatory bodies. And so you have the domestic level and then also the international level. So we'll be, whoa, the end. Did I hit the end? Okay. All right, how does an athlete get to the Olympics? Come on, how do you get to Carnegie Hall? Hard work, practice, 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 exactly. So you have to, right, so you spend your whole life with this dream of making it to the Olympics. And Paris this summer, last Summer Games, Tokyo 2020, because of COVID, they had to postpone it. And then LA in 2028. So this dream of being at the Olympics and representing your country, and there are over 206 countries who participate in the Olympics, maybe minus 2 or more. So this is the pinnacle event, is getting to the Olympics. But so you work so hard to become an Olympian, to get selected, but what types of disputes arise in this? What if your dreams are dashed, and where do you go to contest these types of decisions that are saying you cannot participate, you are not selected? So there are disputes about, it was an unfair selection process, or the eligibility criteria is unfair. The sanction that on me, I wanted, the doping violation was erroneous. Cheating and corruption, betting, those are questions. We see this in the NFL as well. The NFL can be all over sports gambling, but not the players. Didn't the players have to go out 30 miles and they couldn't be in casinos? So they have rules. But rules is rules. So the sports governing bodies establish what the rules are, and if there's a violation, there's going to be a sanction imposed, a discipline imposed, and a variety of types of cases come up. Field of play, or the referee was biased, nationality. Did you just switch your nationality because you didn't get picked to represent this country? And then forced arbitration. Right? So in the Olympic context, there's mandatory arbitration, and Professor Sternlight has written about mandatory arbitration from the beginning. She's been, pointing out the concerns there, and it didn't hit the international sport area until recently. They just accepted, I want to be an athlete, I just accept the conditions that are required in order to be an international sport. Okay, just think, if you think this is daunting, just think of that athlete who is subject to this entire regulatory scheme. So here's the athlete, but who sets up international sport and the Olympics? It's through the Olympic Charter. So again, law of private association, but through the Olympic Charter. And the Olympics, they're ancient, right? So from in ancient Greece, we had the Olympics. Then there was a suspension of the games for over 100 years because they were considered pagan festivals. And then in 1894, they were reestablished. And it was Paris in 1894, and I think Athens and then Paris. So Paris is on its 100th anniversary of last hosting the games. But the Olympic Charter sets up the International Olympic Committee as the supreme authority for all matters relating to Olympic sports. And then the partners in this process, you have the international sports federations, who are the international governing body for a particular sport. So World Athletics is the governing body internationally for track and field. You might have FINA for swimming. Every sport has its own international federation, but also at the national level, we have a national governing body. So we would have, let's say, USA Track and Field, but also subject to the World Athletics. The charter provides for every country to have its National Olympic Committee. And the function of the National Olympic Committee is each country they're responsible for sending delegates and naming delegates to the Olympic Games and regulating Olympic sport in that respective country. So here we have the US Olympic and Paralympic Committee. So the athlete has to comply. They're a member of their NGB, also the regulations of the International Federation. They're a member of their National Olympic Committee. And also in this process, the World Anti-Doping Agency, so we have at the domestic level, the US Anti-Doping Agency, so athletes are tested. They're subject to the World Anti-Doping Code. They have whereabouts requirements. They have to report in where they're going to be. They have to be available for testing. There's a whole slew of prohibited substances and cases of inadvertent contamination. You know, I don't know exactly what's in this bottle, if it's already open. So there's a lot of cases involving intentional and unintentional positive tests. And then at the US level, the statute that creates the USOC requires arbitration of domestic level disputes. And then the Olympic Charter requires mandatory arbitration as a condition of participating. And the requirement for arbitration is embedded in all of the rules. So the athlete has to go to the Court of Arbitration for Sport ultimately, subject to the review. Judicial review is only available in Switzerland. There will be a test on this. And the broadcasters are also bound because the charter says if you want to be a sponsor, so the sponsorship, those type of agreements, commercial agreements, all go to arbitration in Switzerland. So I want to know, well, why Switzerland? What law applies? Is there a role for US courts? And then, is there anything beyond the Swiss Federal Tribunal? And so these are some of the cases that are coming up, some of these types of challenges. So first, I may have covered this, but in terms of the US, we have a federal statute, the US Amateur Sports Act, which sets up the US Olympic and Paralympic Committee, USOPC, that they're our National Olympic Committee, and so they have authority of all matters pertaining to US participation in the Olympics. They send the delegation naming who is going to represent Team USA. And the US statute also provides for that the USOC establish quick and swift and equitable resolution of disputes. So the USOPC bylaws, if there's a selection dispute, eligibility, pertaining to the opportunity to participate, it goes to arbitration. The statute also provides for the Office of the Athlete Ombuds. And I'm going to brag here because I have two. So Casey Wallace is the current athlete ombuds person. So she's the second. Now she got the job. Casey wrote her paper as an LLM student at Pepperdine, and I supervised her paper. And her paper was on incorporating mediation into the USOPC process, because everything's automatically arbitration. And so studying more about mediation, why can't some of these disputes be resolved by mediation? And the sport is definitely the mindset of win or lose. Like, you can't have a tie, or someone's got to win. But Casey, so she wrote her paper on that. I said, send it to John Ruger, who was the first athlete ombuds. And he says, this is a great paper, great concept. Do you want to do an internship with me? She now has his job. Right? And she's great. And she hired one of my other students. So, so they're trying more. Mediation is not used very much or well in this process because the win-lose mentality. And sometimes you might need to have, there's only one slot, so only one athlete can go, so they have to make that decision. But she's doing more to bring her conflict resolution skills into this process and into this sports world, which is great. So if when there is a dispute, and they're going to be coming up Paris is coming up, so the disputes are going to start happening increasingly. The process is to send it to the USOPC. Casey and her team will assist the athlete, try to see if it can be resolved, if there's merit to this. But the athlete has the right to take this to arbitration. And the AAA is actually named in the statute as the provider, so it's under the AAA, and American Arbitration Association has been the forum for these types of Section 9 and 10, these Olympic-related disputes at the national level. They recently were replaced by a new startup called New Era ADR, and all of the arbitrations with New Era ADR are online, and they're more tech, and so we'll see how that goes. Because there's some requirements in the statute. So there's a new provider under that, and you know, the USOPC chose them. That this was actually big news in the arbitration world. But once there is that ruling at arbitration, the AAA at this level, it's a U.S. arbitration award. So you may be subject to the FAA, but it's basically final. You know, Sarah gets to go to the Olympics. Jean, you have to stay home. You know, so, I know, sorry. That's our domestic problem for those types of eligibility disputes. Unfortunately, another rampant problem, it blows my mind to the extent of sexual misconduct, sexual abuse in sport. And to think that Simone Biles, Ali Rassman, on the eve of the competing for the Olympics in 2012 for the gold medal, so Olympic team doctor Larry Nassar goes up to do a treatment in Simone Biles' hotel room, right? And so you saw the instances of, you know, the serial sexual abuse of USA gymnastics, but it's happening at all levels of sports, and not just gymnastics, and not just women. The process used to be, well, go within USA Gymnastics and report it to the person who hired that person who's alleged to be engaging in this misconduct, and even the parents were like, no, this couldn't happen. That doctor, he's doing a medical procedure. And so, you know, I don't want to get into those gnarly details, but awful. There was no process in place other than going to the fox guarding the hen house. So it became such big concern. Believe it or not, Congress took action in 2020 and amended the Amateur Sports Act by the Empowering Olympic and Paralympic Amateurs Athlete Act of 2020. And so they've created an entire new entity to deal with sexual misconduct, sexual abuse claims. It's called the U.S. Center for Safe Sport, and it's headquartered in Denver, and it's an independent investigative body. So reports go, if they have a hotline, they're charged with enforcement of the Safe Sport Code, investigation, and also education. And a report will come in through a hotline or a helpline, and then the Center for Safe Sport has investigators who have to go out and determine was there a violation, was there sexual abuse and misconduct. So it has exclusive jurisdiction. So now it's not the governing bodies who investigate those types of claims because of the potential for conflict of interest there. And the U.S. Center for Safe Sport is charged with this. At the international level, they call this safeguarding issues, but they don't have an equivalent body for safeguarding or safe sport. So the U.S. is pretty on the front lines of addressing specifically safe sport concerns. They're inundated. They've only been around maybe 6-7 years. It took a long time in terms of process design, how to figure out how to address this process from a dispute resolution procedure. But the floodgates of complaints that are coming in have really overwhelmed the agency, and in terms of their ability to, for funding and their ability to investigate without basically a lot of the subpoena powers that public entities would have. So it's there, it's in its nascent stage. It's still, they had hearings in front of Congress recently on how to improve the safe sport process. And because there have been critiques about this in terms of fairness to the accused, so due process concerns. So if you get a report that a coach is engaging in sexual harassment, sexual abuse of an athlete, do you fire the coach straight away? Or do you have to provide due process concerns? What's the level there? So that's one of the critiques. It's also traumatic for the accusers and victims to be cross-examined and going through that process. And you also have the parallel criminal procedures if it does rise to that level. But it is an entire entity now that's been separated from the general AAA process. Also, due to the concerns about doping in sports, the World Anti-Doping Agency was created and has the World Anti-Doping Code. So that's what establishes these are prohibited substances. These are the requirements that athletes have to. There's strict liability for what's in their system. You may be able to argue no significant fault, no fault, or there is an absolute violation. But the U.S. Anti-Doping Agency was created before Safe Sport, but to deal specifically with enforcement of the testing and enforcement of the World Anti-Doping Code. And what's different here is there are two levels. So we have our U.S. Anti-Doping Agency. You can go the first level of arbitration in domestically, but enforcement of the code, WADA has the right to appeal, so anyone can appeal. And the final, there's a second level of hearing, if it gets to that, at the Court of Arbitration for Sport. And I'll give you an example here. I don't know if you remember Floyd Landis. So we had Greg LeMond for years, Lance Armstrong, Greg, then Lance, and then Floyd. So these Americans are winning the century-old Tour de France. And so there was always like, what's going on with Lance? What's going on with Floyd? Well, Floyd wears the yellow jersey, goes into the Champs-Élysées, wins the Tour de France. The next day, he tests positive for a doping violation. And it's a media circus, right? If you've won the Tour de France, and he wasn't represented. He got a new lawyer, but at the time he's like, maybe I had too much Jack Daniels, like quit talking. But he was going. So then he hired Howard Jacobs, who is one of the best athlete advocates, who has guest lectured at my class, and there's a provision that's never been invoked in the Amateur Sports Act saying that the athlete has a right to a public arbitration. Well, arbitration's typically private. But because of the notoriety of this case and kind of the clash between the cyclists and USADA, the doping authority, Howard calls me and he says, do you think we can hold a public arbitration here at Pepperdine? And I was like, yeah. And I was like, I barely asked my dean, and then it was a lot of drama, in terms of, because it got wild. And I thought it was like, hey, can we have a party at your house? And then I thought that meant that they would bring all the expertise, they would set it up. The AAA had never done a public arbitration. And so I loved it because I got my students involved, I got my students paid. I had Sarah, you might have been there at the time. Was it wild?
There was a media room in two of the classrooms.
Yeah. We took over the law school, and Floyd Landis, his family was there. They're Mennonite. They're from Lancaster, Pennsylvania. They fit right in Malibu, and we set up our trial courtroom to have USADA here, Landis, the athlete here, seats for the public. It was live stream video webcast. It was a 9-day hearing. The press was all over it, and it was dramatic. I mean, it started out kind of boring because they're talking about, is this the test, the urine test, and what did the lab tech do? And they they put it on top of a heated thing, then they went and had a smoke, because we're in France. So sorry, France. And then they came back. So they were challenging the protocol, the chain of custody on this. But then we had the French lab come in, the lab technicians, and they needed an interpreter. And it turns out the interpreter, he could, because I'm like, I took 7th grade French, and even I know that that's not the right thing that he's saying. So everyone realized that this interpreter, I don't know if you remember, like Nelson Mandela's funeral, where some guy was the interpreter was like, you're like, that's not sign language. But it was something like that. It was wild. And so we had to fire the interpreter, have a pause in the hearing, go down to the California district court and get one of the interpreters from the courts to come up, all kinds of things going on. And then Greg LeMond testifies. He refuses to answer any questions about Lance Armstrong, but he does report that last night in his hotel, he got a phone call, and it says, if you testify against Floyd, like bad things are going to happen, and it was, and so I'll just say what came out in the hearing. The phone call, they said, well, Greg, what did they say? And it says, if you testify against Floyd, this is your uncle, and we're gonna have to play Tickle the Weenie, right? And Floyd's like, well, or Lamond was saying, who is this? Who is this? And just note to file, if you're gonna do a witness intimidation phone call, how do you block your phone number? Because it was like 867-5309 if Floyd and Amber Land. So then there was this. So Greg said, I had confided to Floyd right after this. He says, it's come clean. And he says, I've been holding something in my whole life. And, it's just, and so he shared in confidence with Floyd, and then he got that call. And so then they're saying, well, what do we do? The witness refuses to answer questions. Can the arbitrator compel him to testify? There's no grounds for not answering. It wasn't attorney-client privilege. It wasn't anything like that. But it was arbitration. And the panel would say, what's your grounds for not answering the question? And he said, I don't have any. And the lawyer, he's like, we have none. But what are you going to do? It's arbitration. And then they're saying, is witness tampering a violation? Is that illegal because it's arbitration? Is arbitration a judicial proceeding under the statute? So all this was happening in that time period. But when it went up to we have Landis 1, 2, and 3, the panel ultimately decided 2-1, so we had a dissent. Mistakes were made in this process, but there was evidence of guilty. One of the other tests, the B sample, showed positive. So then that was the ruling at the domestic level. So Landis appeals to CAS at the International Arbitration for Sport. Now we have a private hearing as opposed to a public hearing. The lawyers brought in some of the same appeal to the public, that doesn't work in Swiss arbitration. So knowing your audience and knowing who the decision makers are, and so they affirmed, basically, it was a de novo arbitration, but they held that he was guilty of doping. They imposed sanctions against the athletes, not the lawyers, for frivolous assertions of misconduct by the lab technicians, and he was suspended. So Floyd takes that CAS arbitration award and he moves to vacate it. He files a motion to vacate that award in California federal court. And so and he was citing basically bias. So one of the FAA standards under Section 10, bias of the arbitrators, conflicts of interest, because he determined that a number of the arbitrators act also as advocates. So you're my arbitrator on this case, wink, The next case, I'll be the arbitrator and you're the advocate. So you could wear two hats. So the arbitrators will also act as advocates. So he cited that as bias, in which case the CAS arbitration award, because it was such a tight club, should be vacated. The court didn't get to that because UCI, the Cycling Federation, they clamped down on him. They said, you're never going to be in cycling again. They did something similar to Lance Armstrong. But even if the federal court in California doesn't have jurisdiction over an international arbitration award, because the rules of CAS say that the seat of arbitration is Switzerland, and that's the exclusive. So to challenge that, he had to go to Switzerland. So why Switzerland? Let's see, the cheese, the fondue. Yeah, it really is. Switzerland, it's home to the International Olympic Committee. It's home to a lot of the international sports governing bodies. The World Anti-Doping Agency is located there, and the Court of Arbitration for Sport and the Swiss Federal Tribunal. So the Olympic Charter sets up the Court of Arbitration for Sport. And why do we have that? So it provides that any dispute in connection with the Olympic Games shall be submitted exclusively to the Court of Arbitration for Sport. And all of the governing body rules, also the athlete agreement, you'd appreciate this, you agree. You have no choice but to agree to, if you want to be in the Olympics, right, practice, 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 you have to waive your right to your national courts, as well as your national laws and procedures. But why? Does it make sense? Because sport decisions need to be made quickly. Specialized expertise is helpful. And so we need to have a single tribunal where all of these, because you can't have lawsuits in 206 countries and the court decisions. So they're saying it makes sense to have a centralized procedure for these types of sports disputes. And so we're establishing the Court of Arbitration for Sports. So CAS has 4 divisions. One is the appeal of disciplinary decisions or appeal of decisions of the sport bodies. Another one is the commercial disputes for example, the sponsors, employment cases. And then another unique feature of the CAS arbitration, I think it started in Atlanta, where it's the ad hoc division where CAS is on site and they are just, if a dispute comes up in the Olympics, we convene at any time of the night, of the day, an emergency hearing and a decision to the extent is possible within 24 hours. Because can Valieva compete? The Russian skater, can she compete? Where were they? Were already in the Winter Games, and evidence came out that she had tested positive. Now the Russians kept that. She was already at the game, but she had tested positive, and it wasn't reported. But she's also 14 or 15 years old, and there are special rights for minors, protected persons. They had to make that decision before they had a full-blown opportunity to determine whether there was an actual doping violation. But anything that happens, a selection issue, so CAS will be on site in the ad hoc division in Paris to render those determinations. So why can't all arbitration be that fast? I get appointed to panels. This is an emergency procedure. Okay, 2 years from now, like, I thought we were in like, okay. And then now there's a separate anti-doping division because you need more expertise just to separate that out. That's the CAS process. So again, if there's a dispute involving a sport governing body at the international level, you can go to the ad hoc division or the appeals, but then it's a final award. It's an international commercial arbitration award, international award that is subject to, it's enforceable under the New York Convention for the Enforcement of Foreign Arbitration Judgments. And because it's considered seated in Switzerland, even if it's in Paris, they're adjudicating, that award is considered final and binding, subject only under the New York Convention to the public policy of the place of enforcement. So basically, like Floyd Landis, they would have to go to the Swiss Federal Tribunal. There are a lot of challenges to CAS. So CAS is efficient. I work with, I take my students to CAS every year. They're very hospitable. They are efficient. There's a lot of cases. They started out with very few cases, and now they're doing FIFA transfer cases, football cases, and all these other. In terms of an international arbitration provider tribunal, they handle 1,000 cases a year, and so there's a lot going on. But the arbitrators are more experienced in determining what was the rule and was there a violation of the rule, but not necessarily what are the other rules. So they aren't applying the law of the country where the athlete resides. And so those are some of the questions that are coming up. Professor Sternlight has challenged forced arbitration for years, highlighting that, but it just came a few years ago, the challenge to this forced arbitration in this Pechstein case, and I'll talk about that in a minute. But in terms of what law applies, Justin Gatlin tested positive. He tried to get an exception for his ADHD medication because it was deemed a prohibited substance. And he says, under the Americans with Disabilities Act, I'm disabled, I have a right to reasonable accommodation, this is the reasonable accommodation. And the Swiss is like, that's an American disease, or that's an American, they didn't buy that. And they said that the ADA, whatever your rights are in America, don't apply here. So even though you're wearing that American flag, you have to lose your right, your access to the national courts and even national law. And so the court, he tried to bring that challenge in federal court, and the court said the US courts have no power to right the wrong perpetrated on one of its citizens. If it just been in the US, but because he's competing as an Olympian representing the United States law doesn't apply. Claudia Pechstein, apologies for all this text, but she, a German skater, also an alleged anti-doping violation, took her case to CAS and lost, appealed that to the Swiss Federal Tribunal, and it was dismissed. And so then she goes to her home courts, and she challenges the forced arbitration as a violation of both German national law and raises the European Convention on Human Rights. So she's saying this violates my human rights, my rights to privacy, rights to engage in my profession. So this forced arbitration is violating not only the violating my right to privacy, but also my right to a fair trial. The European Convention on Human Rights guarantees a right to a fair trial. It went through the German system, and they ultimately said, we can't overturn a CAS decision. Basically, we don't have jurisdiction, and the German CAS procedures seem fair. National law doesn't really apply in this case. So she goes from the Swiss tribunal, and now what's different is she's appealing this to the European Court for Human Rights. And she's invoking this convention, Article 6, Section 1, her right to a fair trial, saying forced arbitration violates that. Switzerland is not a member of the EU, so only Swiss law applies. It's not, so you can be, two African teams can be in a dispute, and ultimately they have to go to Switzerland to make that determination, and Swiss law will apply. Even so, it applies worldwide. And Swiss law applies unless there's another provision, maybe the federation, but they're not negotiating for their state law to apply. Switzerland is a signatory to the Convention on Human Rights. So it goes to the European Court of Human Rights, and they said, CAS arbitration is essentially a fair procedure, but there should be a right to a public hearing. So now CAS had to change their rules to provide for a public hearing, and they've only had one since then, but that was the Pechstein impact. A lot of attention now to the status of trans athletes and intersex athletes. So you may have heard about Caster Semenya, a South African sprinter who has differential sex development, naturally high level of testosterone. Caster Semenya is a woman. She was born a woman. But she has naturally high level of testosterone, and it wasn't until she was competing at the international level that people started to come like, why is she winning? And there's been sex testing in the Olympics, only on women, right? And World Athletics has imposed. We're not always binary. We classify male or woman, but there could be genetic chromosomal differences, and so Caster was determined to have that, but only because the World Athletics has testosterone limits for the women's category. So she's not doping, it's just naturally high level. Shaq is naturally tall. Like, I think he should be, if I'm playing Shaq, he should be shorter. The World Athletics said, under our rules, we're determining eligibility based on the testosterone limit. And so they said, Caster, if you still want to compete in the women's division, then you have to take hormone suppressing medication, or you can compete in the male category. And so she took that up to CAS, the Court of Arbitration for Sport, and the CAS panel in a 2-to-1 decision said, the rule is discriminatory, but it's necessary, it's proportionate. We need to protect women's sports and opportunities for women's sports. And the testosterone level it gives an undue advantage. So she takes that up to the Swiss Federal Tribunal as the process requires. They uphold the CAS. And so Caster takes it again to the European Court of Human Rights. And the European Court of Human Rights is located in Strasbourg, France. And they held that the Swiss Federal Tribunal violates the Human Rights Convention. She still can't compete. Why? World Athletics is a private entity. They're not a member of the European Court of the Convention on Human Rights. Only states are bound by that. So the European Commission said, well, Switzerland violates the human rights by upholding that decision. But World Athletics is like, yeah, that doesn't apply to us. And so Caster it's now gone to the grand chamber. You had I think a panel of 7, and now it's going up to the grand chamber, and so it's pending right now. She still wants to go to compete in the games, and she can't. So we'll keep an eye on that. And the status and eligibility of trans athletes is an issue in oh gosh, you get it all levels of sport in the U.S. and worldwide. You might remember Leah Thomas. How am I doing on time? Am I going overboard? Okay, so Leah Thomas, as competing in the men's division of the NCAA swimming championships, she was ranked maybe 400, near 500, ranking in the male category, and then she goes through the treatment for transitioning, and she's allowed to compete. The NCAA rules said that an athlete can compete in accordance with the gender they identify, and so she was able to compete in the NCAA women's division. I guess it's been 2 years now. She wins, causes a big controversy because they're saying, well, can trans women, are they going to be taking over opportunities for women? Is that affecting the opportunity for girls in sport if you allow a trans woman to compete in the female category? And so that's an issue at the Olympic level as well. And the Olympic Charter has the non-discrimination mandate, but it allows the federations to determine what the eligibility requirements for trans athletes. So World Athletics will have this, unless you transition before, when do you go into puberty? Unless you transition before age 11 or 12, before puberty, trans women can't compete in the women's category. Same with swimming. World Rugby just has an outright ban. So every federation is different. The NCAA changed after Leah Thomas, they changed their transgender policy to align with whatever the sport federation is, so they kind of kicked it over to them. So that's another issue that invokes human rights concerns because there's a non-discrimination mandate in the Human Rights Convention. And okay, I think we're about towards the end, but what do we do about Russia in the Olympics? And are athletes responsible for the acts of their government? I mean, I hope we're not responsible for some of the things that our government does, but what kind of message are we sending so this is the question. A few years ago in 2016, when the Summer Games were in Rio, they had evidence of state-sponsored, thousands of all the Russian athletes. The state, right, the Russian government had the Russian lab alter they would have a pulley, here's the test, here's the clean, send up the dirty on the testing. And so Professor McLaren, who was one of the arbitrators in the Landis case, he was commissioned to do a study by WADA and found rampant state-sponsored doping. So Russia was banned for that, but athletes were saying, okay, you can compete under neutral flag if you can prove that you weren't doping. So now, since Russia has invaded Ukraine, that violates the truce, right? The Olympic truce of peace. The IOC is saying, well, the Russian Olympic Committee is banned, but what about the athletes? Should the athletes not be able to participate in international Olympic sports? So they've just announced that the Russian athletes, if they're politically neutral, they can compete in Paris as individual neutral athletes, no flag, nothing, but they must not support the war. And it's up to the federations to prove, right, how do you prove that someone doesn't support the war? And so they said, well, we're gonna have to go through the athletes' social media. How do you prove that, so if you have you're Russian, you live in Russia, and so that's where we are. So we'll keep tuned from that. But they said, the IOC says, well, it's up to the federations to decide. So some federations are saying no Russian athletes at all. But you have in tennis, Christine Medvedev. We have a lot of Russian athletes or Belarusian. When I play, we're sisters. We play a lot of competitive tennis, and so. When we do the lineup, I'm like, say my name's Westonova, so they'll think I'm Russian, because then they'll scare that ladies' league. So that's happening as well. So the Olympic Charter provides that the practice of sport is a human right. We must have the possibility without discrimination. That's in accordance with the Olympic spirit. So that's been laudatory, not really enforced. But with these new cases, Pechstein, Semenya, bringing in the European Court European Court of Human Rights, it still only applies to the states. But an argument can be made if we're having these laudatory compliance with, it's a human right, and that the sport federations are putting this in their codes. Okay, maybe that's a way to enforce these principles to the private bodies. So I don't know if you remember Qatar, the World Cup, and there were human rights violations, the workers, and everyone thought that was tragic, and yeah, we shouldn't be doing this because there was maybe bribery in the process and the poor conditions of labor and the migrant workers who were dying creating the stadium. It wasn't until they also announced that beer would be banned in the stadium that everyone's like, this is outrageous. So they had to deal with that. I think there's a beer provision now that in the host contract, but the question is these to tackle, right? So should private arbitration finally decide these matters of politics and human rights in sports? They have larger consequences. We look to sport, right, for aspiration. And sports is a model, it's a microcosm of society. So these issues that arise in sport, they have a higher visibility, but they affect us all. And I think that's, the bookstores have been, the Bucanistas in France will still be there. There was a fight on that. They wanted to remove the Bucanistas on the Seine because of security concerns, but the French, people are saying, no, we need to have Paris. Breakdancing is a new sport to look forward to. And with that, I want to thank you. If anyone has questions,
I just had a comment.
yes.
More people have been coming to Las Vegas for the Super Bowl
Yeah.
than the Super Bowl for 20 years. It's not well known, but I went to the first, my first Super Bowl party, I think, in the early 90s, and I was astonished that it was, 300,000 people, and it was fewer than wherever the Super Bowl
Yeah.
was.
Well, other than Taylor Swift, the fact that you have this stadium where you can just walk from the Strip to the stadium and parking's not a hassle. And then the other is the rise of the sports betting, but it's not just going to the sports book, right? Where you just go to that section of the casino. Now you do it on your phone, and you can bet on any aspect of it's not just who wins. It's like whatever, any element of the game. When's the first touchdown, so every aspect, and that's happening in sports. So the leagues like it because they say, they call it fan engagement. It increases fan engagement. But there's also the issues of addiction, but they do have that hotline that says, so I mean, they basically got that sorted. These young kids, high school kids, it's not legal in California yet, and high school kids, I talk to high schools for different things, and these high school, I'm like, what are you doing? That's not even legal. Oh, they know how to do it, but yes.
I'm just curious, I'm dating myself, but what happened with the Eastern Bloc athletes that they used to say were doing all the enhancement? How did those disputes? There was complaints that the Eastern Bloc, before the,
And that predated CAS, but it was at I think the IOC was making some of those decisions, or it's at the governing body level, but that prompted the World Anti-Doping Code because of those concerns about doping that were highlighted in a lot of the East German cases. And so we have the World Anti-Doping Code, which now requires arbitration of those types of disputes.
Administrative process before? Would that be?
Yeah, I think the IOC could make those decisions. And the IOC, being the supreme authority of Olympic sports, has even ceded its authority to CAS, because CAS has ruled on some IOC decisions as well. And so CAS is now really the forum for those types of disputes.
Can I ask a question about
Yes.
the CAS piece? So some of the examples that you gave were examples of individuals whose states would have had more progressive or more protective law. Are there examples of the other, of the reverse happening, where there's an individual from a state that might have progressive or punitive laws that would target the
Right.
individual, whether it's based on gender
Yeah.
identity or another type of
Yeah.
medical issue, but because of these aspirational or more protective Swiss laws.
Right. No, absolutely. Saudi Arabia never fielded women. Women were not allowed to participate in sports. And so the IOC says, if you want to participate, if you want to send a delegation, then you need to have female athletes sent as well. And so they scoured, they actually got Sarah Tar, who was a Pepperdine student in track and field. And so they got 2 athletes before they can compete, but she had dual citizenship. And so that's a nationality, just like what happened here. But that's an example. A lot now with Iran. And the requirements that you have to wear a hijab. And there's so much with Iran in terms of the human rights concerns with that. And so the point of the Olympics is really to promote these types of values across the world. And so if you want to play, you need to play fair. Yes?
Thank you, Professor. I think we could talk for a long time. Interesting. And I think one case of what you highlight is most interesting. My thing is the Castor Semenya.
Yeah.
It's still out there. I've seen Castor. It's
Yeah.
phenomenal.
Yeah.
She's just too good, right?
Yeah.
There's not one line of any evidence of doping
Right.
or anything outside
Yeah.
of water.
Right.
And yet, testosterone is too high. Or genetically, this is where you're born and you're being penalized for it.
Right.
And it'd be interesting to see where it goes. She's 33, 34 years old now. She's 2-time defending gold medals in
Right.
the Olympics, 800 meters, and we don't know what's going to happen.
And she's not the only one. Duty Chand before her challenged these regulations, another South African runner, just naturally high levels of testosterone. And the Duty Chand, in that Cass case before Castor's case, the panel, and they call it lex sportiva or the precedent, but it's still different. It's arbitration, it's flat. Right? There's no appeal of the arbitration or review of the arbitration, so it's flat. But in that case involving Duty Chand, they said you don't have scientific evidence to support this, and so she can compete. And so by the time Semenya's case came up, World Athletics got the scientists. They produced, at least for that panel, enough evidence that there would be an unfair competitive advantage due to the high testosterone levels.
Is that, I'm sorry, is that going to be the test? I mean, is that ultimately how the transgender issue can come down to, whether or not it's an unfair advantage? Because, like you said, I mean,
Yeah.
Shaquille O'Neal is, he's unfair.
Right, when it comes to the women's category, they're looking at biological advantages. So, yeah, there's no equivalent in the men's category saying Usain Bolt, you're too fast, slow down. Yeah.
You start banning Kenyans and
Yeah.
they dominate.
Yeah, yeah.
I mean, what's the process? I mean, is there ultimately, because there's a lot of moral and ethical issues,
Yeah.
I'm sure, at that level that you're dealing with.
Well, that's why this grand chamber of the European Court of Human Rights, because they're saying, we're going to decide. Switzerland, you're a member of the Convention on Human Rights, and so that they're going to. This has gone up to the European Court of Human Rights enforces the Convention on member states, and so that's what's pending right now. But at the regional level of the European Court of Human Rights, they've said that this violates Castor's human rights, and then it's been appealed.
Thank you very much for your comments. We're very interested in this. I'm Jam's now arbitrator.
Yes.
Lisa Lavelle. Sorry. But I have a question, and it seems the problem with the Castro situation is that this is her natural situation.
Yeah, trans is.
But I don't see
yeah.
a real difference. I mean, they banned her because of her. They arbitrarily decided testosterone is the rule.
Yeah.
But when you're looking at somebody who was born with ADHD, it sort of looks like the same situation. That's just who you are. So they established a doping rule for that, which is absolute.
Right.
But again, it's the same situation. The person is born with that condition.
Right.
So can you comment on that?
Well, and so there is a process for a therapeutic use exemption. I need to use this medication, but they need, and it could be denied. And so they're saying, that's not a real, because in Europe, we're not hyperactive in Europe. We stop. We don't even have cup holders. Like we have a proper cup of tea. We go slow. So it's a different cultural. So you would have to go through, there is a process, but if that process is denied, then you have to go through this arbitration appeal saying that's an unfair denial of this therapeutic use exemption, but you can invoke US and ADA.
I understand.
Yeah.
The person has got a certain disability or a certain violation
Right.
because of whatever they're born with. It seems like it's the same situation.
Yeah.
In many ways.
And there are cases, Blake Leeper, and you remember Oscar Pistorius, the South African runner who had, they called him the Blade Runner, double amputee, but he wanted to compete in the mainstream Olympic competition. And so the question was, did his prosthetic legs give him a competitive advantage, right? And they have another, he was allowed to compete in London, then things kind of went south. But Blake Leeper also has as a double amputee, and the same thing. He wants to compete in the Olympic Games, not the Paralympic, but the mainstream events. And they said the CAS panel said the prosthetic legs will give him more than a height. So it would make the prosthetics legs would make him taller than he usually is, and so that gives him a competitive advantage. And so he was saying, you're determining height based on a different demographic. So this based on a European, Asian, as opposed to a taller country. So so many fascinating issues on that. Yes, other questions or yes, and then I'll come back to you.
Someone in this room might know, but in Nevada, I believe the Athletic Commission took up a testosterone matter about a decade ago because a number of fighters were suffering from low testosterone and not able to compete in the ring. So they said, because I have low testosterone, it was because of previous testosterone use that has killed my testosterone generation.
Right.
Therefore, I'm competing at a disadvantage.
Wow.
So I should be allowed to get extra testosterone to at least meet a floor.
Because I was cheating before, and I'm now feeling the effects of that, and so I should be able to get an exception to ramp it up. Yeah.
If you had traumatic head trauma,
Right.
you have low testosterone as a result of that.
Yeah, that's
So
right.
they
Fair.
were trying to build a floor, but then I think ultimately the athletic commission said, no, building the floor doesn't make any sense.
Yeah.
We're just going to ban all supplemental testosterone.
Okay, interesting. And the question is testosterone really the proxy for determining speed? And because I gotta say, men, let's do a little relay right here. No, but I don't know if that's the right measure either, because you can be fast as well. Just having testosterone doesn't mean that you're fast. But yeah, so those UFC, those fights, that's another issue.
This runner saying that maybe they just need to create a floor that other people can come up to, and that
They have a ceiling. Because most women have lower levels of testosterone. Caster Semenya just happens to have a naturally high level of testosterone, and they're saying, you have to bring that down. And she's saying, no, I don't have to. Yeah.
Her hematocrit level's fine.
Yeah, right.
How do we get your PowerPoint?
You can email me, or I have it, Lydia.
Okay. Thank you.
Yes.
Europeans, what about people of color? Because they're discriminated against. And where do they go when they've been discriminated against?
Yeah. That's part of no, racism in sport? Yes, absolutely. Right, that's part of the non-discrimination right, and absolutely. So racism, and you hear it with, in sport where the epithets that are being used by the athletes among the players, or where the fans are coming out, and they're holding the clubs responsible for fan misconduct, and so that's a player misconduct case.
It just seems to me that, the runner from Africa got a lot of pressure because she's black.
Right. Yeah. Right. Yeah. No, I know. It's implicit, explicit. Yeah. Yeah. Fair. No, absolutely fair. Yes, back row, finally.
I came in late. I don't know if you addressed the recent disqualification, I guess, of the Russian team from the last.
Yes.
Why did that take so long?
Yes, thank you.
Oh, so the Olympics are supposed to be free of politics, right? So this is where we're just here to bring the best athletes, and the IOC says we're not a political organization, but we do have rules, and the rules say you can't invade another country. So that was the basis for that, and so they recently have they said the Russian Olympic Committee is banned. They violated the principles of peace that are there. But then the question is, are the individual athletes also banned?
So that was IOC, not CAS.
Those cases can come up to CAS. CAS has some of those cases as well, but the IOC can make the determination, and then if Russia wants to challenge the IOC decision, it goes to CAS. Yeah. And there are going to be more of those cases coming up, especially with this show that you're politically neutral requirement. Yes?
With some of these standards, as far as either trans with the testosterone or with Oscar, it seems like part of what works in the Olympics is getting your body to do the max that it can. trying to do it without any enhancement. So the thing with Oscar that puts him at an advantage is that the blades give him extra torque, right? So no matter what, I just broke my ankle and my son has an amputation. So his blade will give him extra torque that now I can't flex my ankle, right? So if your body is naturally producing more than somebody else, that would be the equivalent of someone going to the gym and putting in more time and building muscle more. So couldn't there be some kind of standard that then gets put in as far as just make your body do whatever it can at natural capacity?
So are you suggesting that the amputee, if they...
So if you get, so for an amputee, it would be then try and get a foot that's going to, so like your foot, because there's different feet that you can get, that's going to be the closest to. So like my son has several feet that he can put on. A blade will give him more torque. There's a different one where he can get more rotation if he wants to go hiking on a mountain. But if he wears a blade, he will outwalk.
This is where mediation could come in, right? We need you to mediate these cases.
Thinking, he will outwalk me super fast.
Right. And I think what the question is, when do these accommodations, let's say, and people with disabilities have a right to participate in sport just like anyone, but when does this give them a competitive, because the technology under Pitsorius, the technology in 2012 was, it's not gonna, does anyone else wanna, use these blades? And, so in 2012, the CAS panel said it doesn't, he can compete. But Blake Leeper, 2019, they're saying the science, the technology on the prosthetics has advanced so much that it does give him a competitive advantage. It does make so that this, and they're saying with swimming or some of the technology, even with uniforms, like you wear a certain type of, it makes you faster in the swim, a certain type of suit. So that's the question that they have to assess, is when is it a competitive advantage in terms of the equal playing field. But I like I love your suggestion. Can we, okay, if this is making him too fast, is there another type of prosthetic that would dial it down a bit? And I appreciate you're telling us about the variety that's out there. So people with expertise, this is where I think we need more mediation rather than just say no, and having private arbitrators who don't know necessarily the science of you can listen to experts, but this seems like where you can facilitate it more. I wanted to get your question. Yes.
So I actually had, my question is more about the procedural matter with the safe sport.
Yes.
And I understand that there's the due process concerns, and so I was curious, is there an appellate process? I understand it's a private entity, correct? So I was just curious about the sort of due process standards, and if there is appeals, what happens if investigations stay open. I know there was the issue with the fencer, the U.S. fencer, who was under investigation through Safe Sport, but it wasn't technically closed, so he could still compete. So just curious what kind of, where we're kind of going with that.
Yeah, those are solid critiques that these cases take too long to process, and about interim measures. When do you say you can't compete even though you haven't had your hearing yet? And JAMS actually is the provider under the Safe Sport Code. Talk to JAMS. But no, it's arbitration. It's arbitration. There's no appeal. And so the coach, the athlete who's accused of sexual misconduct, and where the panel finds that yes, there was, you can't be in the next competition, or you'll never coach again. And they list the coaches. They have a hall of shame of people who've been determined to violate the Safe Sport Code. So they have, basically it's called the Safe Sport Code, but it's the procedural code. Yeah, good question. Good question. Yes, okay. Oh, gosh.
Thank you so much.
Thank you. Thank you. Thank you.
What a mess. So much to think about. Anyway, thank you so much for
Yeah,
coming tonight.
thank you.
To you all for being here.